Hi, this is Josh Blackman. I am the president of the Harlan Institute, and welcome to the 2020 Harlan Institute ConSource Virtual Supreme Court Competition. This year we are handling the case of Espinoza versus Montana Department of Revenue. We are now in the Elite 8 round with the top eight teams who have advanced. For petitioner, we have from East Grand Rapids High School, Luke Spitzley. And for the respondents from Creekview High School in Texas, Makaylia, Askew, and Jacqueline, Aliman. And they'll be presenting arguments today. Petitioner, are you ready to proceed? I think you're on mute, Luke. You can start over whenever you're ready.
Sorry.
That's okay.
Mr. Chief Justice, and may it please the court, Montana's Blaine Amendment violates this court's long-standing precedents by targeting and discriminating against religious use of generally available benefits. The Montana Blaine Amendment is in violation of this court's ruling in Trinity Lutheran by imposing an element of coercion on the scholarship money. That decision held that any coercion forcing the Trinity Lutheran Church to choose between, quote, participating in an otherwise available benefit program or remaining a religious institution was odious to our Constitution. And the same is true of forcing Montanans to choose between sending their children to school and following the dictates of their faith. The decisions of Trinity Lutheran Church of Lukumi also made clear that laws creating, quote, special disabilities on the basis of religious views or religious status, or that, quote, expressly discriminates against otherwise eligible recipients by disqualifying them from a public benefit solely because of their religious character, are unconstitutional violations of free exercise rights. It is important to note that this case does not require a state to fund religious schools, but as Justice Scalia said in his last dissent, that, quote, when the state makes a public benefit generally available, that benefit becomes part of the baseline against which burdens on religion are measured. And when the state withholds that benefit from some individuals solely on the basis of religion, it violates the free exercise clause no less than if it had imposed a special tax. Even after the Montana Supreme Court ended the program for all private schools by leveling down the program, the problem of discrimination towards free exercise rights remains. Their decision held that, quote, the tax credit program aids sectarian schools in violation of Articles Act Section 6, and that is unconstitutional in all of its applications.
Counselor, if I could interrupt you briefly for a second. What is your basis for standing in this case?
Do you want me to state the facts of the case?
No. Article 3 standing. What is your basis for standing in this case?
Okay, yeah. So the parents are the main recipients of the program, and they're the main beneficiaries of the program. When there was a similar program in Zellman v. Simmons.
Right, but with Zellman, Counselor, the voucher went to the student. Here, the money's going to the school.
Yes, you're correct that it is going to the school, but it's going through the school through the choices of the parents.
Right, but it's as I understand it, taxpayers can donate money to this program, and they can designate where the money is being spent. The parents of the kids have no role in that other than sending their kids to the school.
Well, that's not correct, Your Honor. They can designate whether or not to donate, and then the money is sent to SSOs, school scholarship organizations, who then give the money to the parents, and then the parents, they give money for tuition for the parents to go to one of their...
Right, but the money's going to the school, and there's no guarantee that Espinoza's kids even get a penny.
Well, for the facts of this case, there is. The scholarship organizations would lose significant funding because of the contributors not being incentivized by the scholarship program by Montana anymore. And then as Espinoza, the parents would lose the benefits for tuition from the scholarship organization, and then that would provide the Article 3 injury for
right,
the case.
But let's just be clear. does the scholarship program exist anymore?
No, currently not for private
Right.
schools.
So there's no more ongoing discrimination. Everyone in the state of Montana is being treated equally. No one gets the money. What's your ongoing Article 3 injury then?
Yeah, so we would say that because the intent and the means to the end is the same as Rule 1, which they originally had, but the Montana Supreme Court removed from the trial court, because both Rule 1 and leveling down, the goal of both is to make sure that you're complying with Montana's Blaine Amendment.
Right, I get that, but as a result of leveling down, it seems the injury is gone. In other words, you need to have Article 3 injury at every point, right? At every juncture, you always need an injury. What is your injury right now? It seems that there's no more injury because the program's been killed.
Yeah, I would just defer again to the idea that if the intent, you're complying with a discriminatory dictate, while that is not constitutional. For example, after Brown v. Board of Education, Prince Edward County in Virginia did not want to integrate. And so what they did is they leveled down their school system, their public school system, and they closed it. They did not collect taxes for it. And they said that there was no discrimination. It would affect all races of children in the county. However, when the Supreme Court ruled on that case, they said that...
Counsel, isn't the Equal Protection Clause a little bit different, because the Equal Protection Clause requires equal treatment, whereas the Establishment Clause is the opposite, says you can't treat religious and non-religious alike.
Yes, that is correct, Your Honor. However, I don't think the Establishment Clause is as central of an issue as the Free Exercise Clause. In cases like Trinity and Church of Lukumi said you can't single out people based on their religious status and treat them differently because of that. And that's what's happening in this case, Your Honor.
Well, let's go about Lukumi first. Is there evidence that there's any sort of anti-Catholic or anti-Christian bias here?
I would say that is not necessary to settle the case. While there was originally, when the Blaine Amendments were being passed at the end of the 19th century, there was a lot of anti-Catholic bias then. However, many of these amendments have been readopted, such as Montana's itself, which was readopted in the 1970s. And at that time, there was many actually religious leaders that were supporting it because they wanted to.
All right, so is Lukumi on point then? Does Lukumi help your case?
So I would say Lukumi is not as big as Trinity Lutheran, but I would say Lukumi does point to that you can't discriminate on religious status.
Okay, let's talk about Trinity Lutheran for a bit, right? Trinity Lutheran involved tire scraps, right? There's no religious use for a tire scrap. Isn't there an easy way to distinguish away Trinity Lutheran from your case?
Yes, well, there is no for tire scraps that isn't going to have a religious basis. However, I don't think whether there's a religious intent or not for what practices or use the funds have. I don't think that matters because there's the element of private choice. The government funds aren't simply flowing from the state coffers to schools. There is several layers, like the parents.
But doesn't that insulation mean that the parents aren't the right plaintiffs? Shouldn't the plaintiffs be the scholarship organization or the school? I still don't see how Ms. Espinoza has Article 3 standing here.
Well, I would again defer to Zellman, and the beneficiaries are not just conduits for what the money flows through. But
in Zellman, wasn't the voucher going directly to the families? It was going directly to the family. There's no intermediary, right? In other words, the family could choose which school they spent the voucher at. Wasn't that the facts in Zellman?
Yes, that's correct, Your Honor. So there isn't exactly as tight of a relation in the money and the benefit, but still, the money from individual donors that is incentivized by the program goes to these scholarship organizations and then goes to the parents who are the intended beneficiaries of the eventual intended beneficiaries of the money.
All right, you can proceed with your argument, Counselor.
must not allow the guise of leveling down a shield from the same insidious discrimination towards individuals' free exercise of religion. It cannot simply stand that the state's end of discriminating against religion can be protected due to the use of different means. While Rule 1 only targeted religious use and leveling down targets all use for private schools, both forward an impermissible end of the state. In 1964, the Supreme Court saw through the maneuverings of Prince Edward County, which adopted a similar approach by closing its public schools in hope of avoiding integration in the wake of Brown v. Board of Education.
But Council, come on, right? In Prince Edward County, the Virginia government was trying to evade Brown. We all know what they were trying to do. Here, the Montana Supreme Court was trying to comply with state law. I think it's an unfair comparison.
Yeah, I would say that because they are trying to comply with state law, there is a difference, but that state law that they're trying to comply with has the free exercise concerns and violates the free exercise clause at the federal level.
All right, may proceed.
In that case, this court did not let leveling down shield the discriminating party from review, and this court ruled Prince Edward County's actions unconstitutional, as it should in this case. Additionally, in Arlington Heights, this court held that if a state government does something for their own constitutional requirements, but does it through a discriminatory, unconstitutional reason, that action is also unconstitutional. Respondents hold that this court should follow in Black v. Davies' ruling without failing to address the unprecedented nature of that case and the severe delineations between the fact patterns in this case and in that case.
Counsel, let me ask you a question, right? Is there any way to rule in your favor without killing Article 10, Section 6? In other words, can we rule from Espinoza without disturbing the Montana Constitution?
I do not think you can provide relief without striking down the Blaine Amendment. I would say there could be some debate whether you need to do it facially or do it as applied, because I do think that it is possible that there are some applications of the Blaine Amendment that would not present a free exercise violation. However, I think at the very least you need to strike down.
And you think it's unconstitutional on its face. That's your position?
Yes, Your Honor.
Now, I know you think Trinity Lutheran is the strongest case for your to argue it is unconstitutional. That was a 2017 case. If you had brought this case in 2016 before Trinity Lutheran, would the Blaine Amendment still be unconstitutional?
I think that you could make the argument using Lukumi, and you could talk about Locke, which in of itself says the only reason that program did not present a free exercise concern is because it went a long way towards including religion in its benefits. So I think you could make the argument, but I would say that it has definitely been made easier in the wake of Trinity.
Maybe Trinity Lutheran can't be read that broadly. I mean, it was somewhat of a fractured opinion, wasn't it?
Yes, it was, Your Honor.
How so? Tell me.
Well, there were some disagreements. For example, Justice Thomas and Gorsuch talked about religious use, status, spending, various categories, whereas the element of coercion was focused on by the majority opinion that these churches had to choose between either being a church and following the dictates of their faith and what that entails, or participating in receiving a government benefit. And that was the most important element, I think, that the court agreed on was coercion.
Okay. All right, counsel, you have about a minute and a half left. You may proceed.
Up to 37 of our nation's states have varying forms of no-aid provisions in their constitutions, and many have existed for well over 100 years. The Locke is the only time that this court has ruled a no-aid clause to be not a violation of free exercise of religion. These facts, against a backdrop of numerous cases requiring neutrality with regards to religion, from Trinity Lutheran all the way back to Everson, makes Locke an exception to the rule. Indeed, the facts of this case were exceptional because while the law banned a narrow field of devotional theology, it allowed for students to use the scholarship for all other form of religious classes and let them go to pervasively sectarian institutions. Indeed, upon closer inspection, the scholarship program was allowed to stand only because it, quote, went a long way towards including religion and its benefits, which leaves the question of if lack was even an exception to the rule.
Okay, about 30 seconds left. Maybe, or yield, whatever you like.
I yield the rest of my time.
Okay, very good. Thank you so much. All right. Thank you, Luke. Makaylia and Jacqueline, you have 15 minutes for your position. You may begin whenever you're ready.
May it please the court. My name is Jacqueline Aliman.
My name is Makaylia Askew.
We represent the respondent, the Montana Department of Revenue, in today's case.
We are arguing that the Free Exercise Clause of the First Amendment does not prohibit states from withholding funding from student aid. The history of religion in regards to education and the history of the Free Exercise Clause upholds the constitutionality of the refusal to fund religious institutions, and two, the No Aid Clause is constitutional.
First, when looking at the history of religion in regards to education and the Free Exercise Clause, the refusal to fund religious institutions is constitutional. Brown v. Board of Education held that the federal constitution makes no reference to schools or education, leaving to the states the establishment of public educational systems and its financing, and the contours of the right to a quality public education. Montana's constitution has done exactly this, by reflecting the state's interest in respecting the distinctive nature of religious education, while avoiding interference in religious schools and protecting its state's funding resources for public education.
It ensures public accountability for education and avoids entanglement with religion. The treatment of religion echoes the kind of symmetry long associated with the protections for religious liberty. Employment Department Division of Human Resources of Oregon v. Smith held that when addressing the constitutional protections for the free exercise of religion, we can establish the general proposition of a law that is neutral and of general applicability need not be justified by a compelling governmental interest, even if the law has the incidental effect of burdening a particular religious practice.
All state constitutions have provisions that address the relationship between the institutions of religion and their government. Today, 38 states' constitutions specifically contain provisions that prohibit public monies being spent in aid of religious institutions or religious education.
Okay, Counselor, if I can let's start with Trinity Lutheran, which is where I think your friends on the other side spent most of their time. Trinity Lutheran says you can't discriminate on the basis of religious status, right? Churches need not apply.
Yes.
Isn't that exactly what your Blaine Amendment does? It's denying funding on the basis of the religious status. That's why they're denying funding.
I'm sorry, I can barely hear. Can you please repeat your question, Your Honor?
Isn't this decision denying funding on the basis of religious status? Is that exactly what's going on?
No, that is not, because the no aid clauses that is put forth by the Montana Constitution does not discriminate against religion. It is just protecting its public fundings.
I get that, but it's saying if you're religious, you don't get funding, and if you're religious, you do get funding. Isn't that exactly what Trinity Lutheran said you can't do?
Well, Trinity Lutheran, they excluded the churches and any otherwise neutral and secular aid program, and that violated the First Amendment's guarantee of free exercise of religion because it discriminated against the eligible organizations based solely on their religious character.
Right.
And unlike in Trinity today, the No Aid Clause is not specifically discriminating solely against religious schools, but it's withholding funds from all private organizations.
Forget the scholarship program. I'm talking about the state constitution. It says no aid to any religious organization. It says it very clearly. If you're religious, you don't get it. That's the status. So how does this square with Trinity Lutheran? This seems to be in tension with Trinity Lutheran.
Sorry?
This rule seems to be in tension with Trinity Lutheran. It says no aid in the state constitution.
I'm sorry, Your Honor, I'm not familiar with the facts of what you're trying to state.
All right. Are either of you familiar with footnote 3 from Trinity Lutheran?
No, Your Honor.
Okay. All right. You may proceed with your argument.
The constitutionally particular quality of religion is deeply rooted in history and precedent. Montana's provision at issue today concentrates on prohibiting the payment from any public fund or money from any sectarian purpose or school in such a like controlled in whole or in part by any church, sect, or denomination. That several state constitutions place the free exercise clause and no compelling support clauses within these same provisions, as the no funding clauses indicate the mutually reinforcing nature of principles. The free exercise clause of the First Amendment states that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Stroud v. Albanese held that the free exercise clause is written in terms of what the government cannot do to the individual, not of what the individual can exact.
Counselor, if I could interrupt for a second, what should we do with this history of bigotry behind the no aid provisions, these blatant amendments? How should we consider that in our analysis?
Well, Your Honor, the history of the no aid provisions, it was simply a forklum in a century-long struggle over the propriety, and it simply served as a capstone on an 8-year controversy over that ranged along the school funding questions, and it simply was used in order to make public education available for children of all faiths and races. And in doing so, it made sure that by not letting state governments and federal governments control what funds religious schools get at all, it made sure that those religions were able to freely exercise whatever they wanted without the government looking over their shoulder.
All right. Well, Counselor, tell me about the case of Zellman versus Simmons Harris. How do you distinguish your case from Zellman?
In Zellman, the case, in Zellman, the court held that the court held that it stands for a proposition under the Establishment Clause that the link between government funds and religious training is broken by the independent and private choices of recipes. And so, in doing so, sorry, would you mind rephrasing your question?
How do you reconcile your case with Zellman versus Simmons Harris?
Well, with Zellman, although the court has found in the public court and religious institutions to be permissible under the Establishment Clause, it is still not held that it is such support to be required under the Free Exercise Clause.
But if we declare the Montana Constitution unconstitutional, right? We set aside the Montana Constitution. You could give vouchers to religious schools. So what's the problem? Why can't we just declare your state constitution unconstitutional?
Because in the Justice Stevens dissent stated that whenever we remove a brick from the wall that was designed to separate religion and government, it can increase the risk of religious strife and weaken the foundation of our democracy. And if this court were to find that Montana, absent Article 10, Section 6 of the state constitution, is required to fund religious institutions in order to not be discriminatory, they have to open doors as a Madison state.
Well, but I think your site, your counsel,
public dollars to private religious institutions. Sorry, could you repeat that, Your Honor?
I think you're reading from the dissent, aren't you?
Yes, Your Honor.
That's not the majority opinion. But how do you reconcile your case with the Zellman majority opinion, not the dissent?
Well, it's to my knowledge that the majority opinion found that the was constitutional. However, that voucher system was with at least the plain lessons that were being made. And in today's case, the reasoning why Montana Montana is not allowing schools to receive funding, it's because it would open doors to let schools buy, you could say, Bibles or continue to help them express their religion to others. And if by doing so, it would allow the government to step into their religion and try and lead them to something else.
Okay, you can proceed, Counselor. You can proceed with the argument.
Jackie's talking on mute.
Sorry. Okay. By affording state and local governments latitude to resolve close church-state questions, federal courts achieve some of the desirable effects of originalism, namely political accountability and judicial consistency. When states are free to create their own policies and programs reflective of their increased need for both separation from and partnership with religious institutions.
Well,
To refuse
Counselor,
states'
you
attitude on borderline church-state issues,
Counselor,
and
can you hear
to
me?
interpret the Free Exercise Clause to force Montana to fund religious education would be contrary to this settled understanding that would be disemboweled, if not completely collapse the play in the joint principles established in Locke v. Davie between the Religion Clause this court has wisely and repeatedly recognized.
Counselor, can you hear me?
Yes.
You mentioned originalism. Can you give us some evidence of original or historical documents to support your position?
I'm sorry, can you repeat that very quickly?
Can you give us some historical evidence that supports your position? How about I chat? Actually, you can't hear me.
Okay.
Can you give us some historical evidence to support your position?
James Madison's memorial would support the position of closing those, of keeping those two separate.
Okay. All right. Thank you, Makaylia. You can continue.
James Madison, in his remonstrance against religious assessment, furthers this by stating to hold as much now would be to open the door to redirection of scarce public dollars to private religious institutions, invite entanglement with and regulation of religious instruction, and to steer in the opposite direction from the efforts by states at our nation's founding to avoid establishment, as a religion then of every man must be to the conviction and conscience of every man. In addition to the history of the Free Exercise Clause and past precedent upholding the constitutionality of the refusal to fund religious institutions, founding era evidence shows that the No Aid Clause is constitutional. Several early state constitutions barred taxpayer support to religious institutions while also disestablishing the church and protecting free exercise. By contrast, the First Amendment includes the establishment and free exercise clauses while also saying nothing about the taxpayer support of religious institutions.
The First Amendment therefore leaves the question to the people. James Madison's principal opposition to state funding of religious institutions further confirms that the No Aid Clause, which is based on those same rationales as the Constitution, recognize that most private schools in Montana are religious. Legislature provided that the tax credit program must be administered in compliance with Article 10, Section 6 of the Montana's Constitutions. It provides that the legislature, school districts, and public corporations shall not make any direct or indirect payment from any public fund for any sectarian purpose or to aid any church school, controlled in whole or in part by any church, sect, or denomination.
The current No Aid Clause was enacted in the Constitutional Convention of 1972. The delegates show that they enacted the No Aid Clause in order to protect religious liberty. The delegates believed that the No Aid Clause would prevent the government from gaining undue influence over the religious schools, preserve funding for public schools, and protect the rights of taxpayers with religious objections to state aid. The Montana Supreme Court says it protects religious freedom. The state enforced the No Aid Clause as written, fulfilling the delegate's goal of protecting...
And you have about 40 seconds left, Counselor. You can proceed.
The Free Exercise Clause of the First Amendment does not prohibit state from withholding funding from student aid programs because based on past precedents, the refusal to fund religious sanctions is constitutional. And James Madison in his memorial states that the history of the Free Exercise Clause also upholds that there is no violation because the original meaning of prohibition on free exercise would not have encompassed a state constitutional meaning of prohibition on government aid to religious institutions. And the No Aid Clause does not violate the Free Exercise Clause because it protects public funding and accounting for public entities.
Okay, that's time. Thank you so much. We now have 5 minutes from petitioner. Luke, you can begin whenever you're ready.
Your Honor, the first point in rebuttal is that Montana doesn't have to fund any religious or educational schools at all for private schooling. But when it does so, it has to do so in a non-discriminatory fashion if it's going to have a generally available and public benefit. And very briefly in their introduction, they mentioned Unemployment Division v. Smith, but I don't think that is really related to this case because this is the Blaine Amendment's application is targeted and it's not a generally applicable law. And then they talked about how there are many Blaine Amendments across the states. There's actually up to 37. But we would say that you could rule on a case-by-case basis as the facts of each case dictate. For example, Utah's constitution has a Blaine Amendment of its own. However, it only bans direct appropriation.
So, Counselor, let me ask this question. Is it possible for us to declare the Montana Constitution unconstitutional, but perhaps some of the other 37 states would retain their no aid provisions?
Yes, that's exactly correct, Your Honor. The language can starkly differ, and I don't think it's necessary to be too hasty and strike down all of these Blaine Amendments at once.
Could we even do that? I mean, is that even an option in this case?
I would not pursue that path, no.
No, I mean, what remedy... In other words, what remedy do you actually want us to do in this case? What do you want the opinion to say in this case?
We would want the Blaine Amendment to be struck down facially and all of its applications to provide leave.
But if we strike down the Blaine Amendment, if we be precise, we don't strike down laws, we declare laws unconstitutional, right? If we declare the Montana Article 10, Section 6 unconstitutional, how does that help your client, right? Does that reanimate the scholarship program? Does it bring it back to life?
Yes, Your Honor. Then what would happen is the scholarship program could be reenacted.
Well, reenacted, but with a legislature has to do that. In other words, even if we declare the Montana Constitution unconstitutional, how do we force the Montana legislature to reanimate this program? It's dead.
Yeah, sorry, I misspoke, Your Honor. It would be it would not be reenacted. It would be restarted with the same text, and you could just apply the same text that was enacted by the Montana legislature, and then the benefits could flow to the parents again, which would enable them to participate.
Right, but I don't understand if the program is dead now. How does it come back to life? How does it resurrect? To use a phrase, right? Happy Easter, everyone, right? How does it come back? What? How do you do that?
I think you can just apply the law on the books that they level down, and you can just treat it. I don't think you need to necessarily ask Montana to reenact the law, because then you would be forcing the state to fund education, which is not at all what we're trying to rule in this case. I think you could just use the law on the books, because when Montana leveled down, as you noted, they did not strike down the law. They just ruled it unconstitutional, and I would just ask for the judgment to be reversed.
Okay, you have about a minute left, Counselor, or you can yield your time.
Zellman is more direct in its benefits, but the program here is still designed to provide educational opportunities for families. That's the end goal of the program. And if it is leveled down and kept that way, as the Montana Supreme Court did, then these families can lose their ability to send their kids to school. And so that provides them the Article 3 injury necessary. And then on the issue of do foundational tax or arguments go against us in this case, we would strongly disagree that this program is the same type of program that Madison was talking about in his remonstrance, because this is a generally available benefit. It's not targeted.
But 20 seconds left, Counselor. About 20 seconds left. 15.
It's not targeted. It's a generally available benefit. And there's elements of private choice, so I don't think it's the same as the issue in his remonstrance. And we ask you to reverse the ruling of the Montana Supreme Court and hold the exclusion of our plaintiffs due to their religious status to be a violation of the Free Exercise Clause.
Okay, thanks so much, Luke. Respondents, you have 5 minutes rebuttal time. You can begin whenever you're ready.
May I please look forward? The opposing counsel states that because of Trinity Lutheran Tacoma, the no aid clause is unconstitutional. However, the court in Trinity did not actually hold that states were required to fund the building of churches or to fund explicitly religious activity conducted through churches, or fund explicit religious activity through churches, religious schools, or other religious institutions. And such a rule would fundamentally rewrite constitutional arrangements that have long protected religious liberty and limited the influence of the state over religion. The opposing counsel also states that the program was discriminatory towards religion. However, 10 of the 10 schools that had participated in the program, only one was actually non-religious. And so the state, just to be safe, enacted the entire program in itself so that it would not be discriminatory towards religion nor towards non-religion. And lastly, the opposing counsel also labeled the no aid clause that Montana uses as a Blaine Amendment. However, the Blaine Amendment is not discriminating based on religion because it was voted on as a proclaim in a century-long struggles with over the propriety, and it served as a capstone on 8-year controversy that ranged along the prior historical school funding question that had everything to do with the biased climate on the post-Reconstruction era and the concerns about the power the federal government had over education, as well as the Catholic animus. It was used in order to make public education available for children of all faiths and races, while still respecting Jeffersonian notions of church-state separation. Those who categorize this Blaine Amendment as a singular exercise in Catholic bigotry would still give short thought to the historical record and the dynamics of the time. Because of this, even if the court were to find that Article 10, Section 6 of Montana's Constitution was a Blaine Amendment, because it actually protects religious liberty, it is not discriminatory towards religion.
But how do you say this protects religious liberty when all these religious schools want the money, you're not giving it to them? I mean, these religious groups would disagree. They say that you are violating their religious freedom.
Because, Your Honor, by not giving them this liberty, it would make sure that the state stays within its line of not overstepping into religion and trying to establish a religion of their own, which would be in violation of the Establishment Clause.
Okay, you may proceed, Counselor.
It is for these reasons we pray that the court will in favor of the respondents, the Montana Department of Revenue, and uphold the lower court ruling.
Okay, thank you so much. You guys did wonderful. Very, very proud of you. If you notice, my questions were a lot harder than they were in the first round. I hit you on standing. I hit you on Trinity Lutheran's footnote 3 and the Gorsuch concurrence. I gave you a lot of things that you probably weren't ready for. I wasn't trying to stump you. I wanted to see how you'd respond when I threw something at you. They had no idea what was going on. You will all maybe go to law school one day. You're going to be attorneys one day, and you'll go to a judge, and he'll ask you a question, and you have no idea what the answer is. But the talent is figuring out how to say something intelligent and sound good. And I think you all handle my questions as well as could. I know you had technical issues, Jacqueline. Don't worry about it. This stuff happens. We live in a Zoom world now. This is our existence. I stare at my screen 8 hours a day. No more actual students to talk to. But I think you did as well as you could in the circumstances. Sebastian, is there anything you'd like to add?
Yeah, you all obviously made it to this point for a reason, and you let it show. Justice Blackman obviously reveled in asking some really difficult questions, so good job sort of rolling with those punches. And especially great job, Luke, doing it solo. I'll try not to dock you too many points for the Michigan pennant as a Wisconsin alumnus.
Oh, boy. We'll let that one go. And it's okay. He's in Grand Rapids. It's okay. It's almost like neutral territory. Do you have any questions for us, Luke or Jackie or Makaylia? Anything you want to ask us? No?
You said you're gonna figure out tomorrow when?
Yeah, either today or tomorrow. We're not exactly sure, but we'll let you know probably by tomorrow at the latest who's advancing to the next round.
I actually had a question.
Yes, Makaylia, go ahead, please.
So, do you know if the next round will be finals, or if you're going to cut the teams down even more?
No, we're going to do a final round. We did the 8 to try and get a better sense. I don't know who's going to advance. We have one more round after you, so we haven't made our decision yet. We haven't done the scoring for everyone. But the final round will be just two more teams. So this is the last, this is the semifinal, and then we have final rounds with top 2. So the top petitioner team will advance, and the top respondent team will advance. That's how we're going to structure it. Okay? Very good. Jackie, any questions for us?
No, sir.
Okay, I'm sorry you couldn't hear us. I know it's not your fault. I don't blame you at all. It's the technology.
It's okay. I think it's because I disconnected my AirPod.
Yeah.
And, it just made the sound very weird. I couldn't hear for anything.
It's okay. You did the best you could. We understand entirely. All right. I will close this round. We have another one starting in about 15 minutes. This is our back-to-back-to-back day. Thank you so much. And if you have questions, you can email me. You're not too far from Houston. If you're ever in Houston, you're welcome to come visit my class. The door's open. Assuming I have class. Maybe I'm teaching on Zoom the rest of my life. I don't know. But you're always welcome to visit in Houston, okay? All right. Take care, everybody. Bye-bye.